We made it. We made it. It's time. It's time for the dream team to take the wheel. No. This is gonna be freaking good, guys. This is gonna be good. This just really is. So I got my incense going. Stay calm. I have a feeling I'm gonna be screaming a lot. Blood vessels are gonna pop. Okay, speed is correct. Let's go. Let's move it forward.
All right.
Your Honor, turning next to the question of exhibits. Has the court received the faxed copy of a letter?
Yes, I did. I have a letter before me with today's date that is a two-page letter that lists various prosecution exhibits and a brief explanation of the defense objection.
Would the court wish me to formally go through that list, or would the court please I can introduce this as an exhibit and have it lodged? Or
Well, we'll file this as a letter to the court so that the record is clear as to what it is you are objecting to. I'd like to take these, since we only have objections to approximately 20 or 25 exhibits out of the almost 500. My suggestion is we take them one at a time, since they appear to, although some of these can be grouped together.
Your Honor, if the court pleases, I'd like to first give an overview of certain categories of exhibits
Certainly.
that I would like to lodge objections to. The first concerns those exhibits of the crime scene and the victims at the crime scene. As the court will recall, there were objections lodged at the opening of the trial on 352 grounds to several of the crime scene photographs. I recall arguing then that I recognized that this was a murder case and that in all murder cases there are crime scene photographs. I objected, however, to the number, which I thought was repetitive, which I thought was unnecessary, and which I thought that there were other ways in which the relevant facts could be displayed in a less prejudicial form and fashion. I simply, for the record, renew my objection to those exhibits now. It is my hope that all of the relevant photographs of crime scene victims are listed, and it is my intention to formally lodge an objection to the crime scene photographs, with the exception of one view of Mr. Goldman and one view of Ms. Brown Simpson. Any repetitive photographs, I hereby lodge an objection on 352 grounds. Similarly, Your Honor, the court will recall that the defense lodged very vocal and strenuous objections to the autopsy photographs, and for the record generally, I would renew our objections now. Certainly, in the light of clear reflection, the court can see why the defense had strong objections to some of the more graphic photographs that were shown to the jury. Our worst fears were apparently realized because there were several different occasions when several jurors appeared to suffer some manner of dis-ease upon viewing the photographs. I think that on 352 grounds, they should not be allowed to be introduced into evidence, and I want to confirm for the record our objection to those exhibits as well.
It's a murder trial.
So those are the general categories, Your Honor. There's also, I have a question, and I spoke briefly with Mr. Darden about it this morning, as to the propriety of introducing resumes of some of the experts, particularly the resume of Dr. Lakshmanan, as well as the resume of Mr. Weir. I think that on 352 grounds, they are really unnecessary because there was extensive qualification of each of those experts as to their background.
All right, as to
Who cares?
407, the resume of Dr. Weir, that was withdrawn.
Very well.
And the only relevant other resume would be People's Exhibit 295, which is the resume of Dr. Lakshmanan.
Then as to that one, Your Honor, I think particularly with Dr. Lakshmanan, there was extensive testimony.
Then who cares if they submit the resume? Who
As to the
cares?
nature and extent of his education, as to the quality of his past experience, and given the care with which he was qualified as an expert, I would argue on 352 grounds that the introduction of his resume is unnecessary and an undue use of the process. Turning specifically, Your Honor, to the objections that are listed in the letter to the court, Exhibit number 8
That's
was
the
a
part I
lesson
want to
plan
see, though, Bobby.
that allegedly concerned a conversation that Mr. Shipp may have had either with Mr. Simpson or with Ms. Brown Simpson, and we lodged an objection to that exhibit on hearsay grounds. The next exhibit would be exhibits 9 and 10 and 11, and I believe these are the photographs that concern Ms. Brown Simpson that were allegedly recovered from the bathroom drawer in their home, where there was an attempt to introduce the photographs through Mr. Shipp, but there was no foundation laid. There was then a second attempt to introduce the photographs through Denise Brown, and the only foundation that was offered was that she found them in '89 or so in a drawer, but she could not authenticate them, particularly as to time. I recall there being a sidebar in an effort to clarify the problems evidentiary-wise, and I, on behalf of the defense, lodge objections to each of those 3 photographs at this point.
All right. And you're referring to the 3 Polaroid-type photographs?
That's correct, Your Honor. I next lodge objections on behalf of Mr. Simpson to exhibits 14 and 15. I believe that those were 2 of 3 photographs brought to the court during Mr. Shipp's testimony. Only exhibit 13 was offered before the jury, and for those reasons, I think that there's no basis to introduce exhibits 14 and 15.
Okay.
Exhibit 16 and its corollary 16A, I believe, and please, Mr. Darden, correct me if I'm wrong, that exhibit will be withdrawn.
That is correct. 16 and 16A have been withdrawn.
Very well. Consistent with the arguments that I stated preliminarily, we lodge objections to Exhibit 43 concerning the victims found at Bundy, which is a large board, and Exhibits 43A through E, which are included on that board. Similarly, Your Honor, we lodge objections to Exhibit 59 as well as 59A and B. Those, again, are crime scene photographs of Mr. Goldman at Bundy. The next 2 exhibits, Your Honor, concern a photograph that was taken inside Bundy, the kitchen area, I believe, of a knife that was displayed on a counter inside
Oh my
the
God,
Bundy
there was
residence.
a knife on a kitchen counter?
I
No
don't think
way.
that there was any
No.
testimony demonstrating the relevance of that knife to the issues that are
Was there a
germane
toilet
to
in the
jury this
bathroom?
matter.
Because that's
It
crazy.
was simply one item that was found on a counter. It was never offered or displayed to Mr. Lakshmanan, suggesting that it could have had any relevance in terms of a weapon used at the case. And I think both on relevance and really 352 grounds as well,
all the
that
evidence
there's
we object
no
to.
real need to have either of those 2 photographs introduced into evidence. Generally, Your Honor, exhibits 87 through 96 are,
Those have been withdrawn
they've been withdrawn as well. Very well.
as not being ripe at this time.
Correct. Next, we turn to exhibits 132, 133, and 134. They are photographs inside the Rockingham garage.
All right, give me 2 seconds here. All right, 132, 133, and 134.
I recall there was an effort through Mr. Lang to authenticate and to lay a foundation for the introduction of those pictures, unsuccessfully so. I have listed on my sheet that there was another attempt to introduce the photographs through Mr. Kalin. Quite frankly, I don't recall the nature of that testimony, and I was unable to locate that transcript prior to coming to court. But as a cautionary note, I would lodge an objection on foundation grounds because I do not recall Mr. Kalin's ability to properly attest to when those photographs were taken. I've spoken already about Exhibit 295. Exhibit 334 and 335, Your Honor, were 2 knives that were initially at least shown to Dr. Lakshmanan. I don't recall the quality of foundation being laid as to those 2 knives, as I do recall having been laid to Exhibit 332 and 333. My recollection was that each of the 4 knives were initially presented to the doctor, but that there was more extensive effort to discuss Exhibits 332 and 333, and I don't specifically recall the same care in seeking to draw some connection, even theoretical, of Exhibits 334 and 335, and that's the basis for my objections to those 2 exhibits. Exhibit 337, Your Honor, was a printout from a book from Werner Spitz and a Mr. Fisher. I had occasion to review that document on Wednesday. I do not think, however, I do not recall specifically what was offered as to the relevance, and as a precaution, therefore I lodged an objection to it.
This is the Lines of Langer exhibit.
339, Your Honor. Withdrawn. That's incorrect. The next would be those boards consistent with our stated effort to exclude and eliminate from presentation into evidence of any autopsy-related photographs. As the court will recall, during the 8 days of direct testimony, there was meticulous attention paid to each wound, both from the graphic photographs to the same locations on the blow-ups of the actual diagrams, to there also being a verbal recitation and description of the various wounds. I do think that on 352 grounds, given the totality of the evidence and that which the jury has already been allowed to view, that there is a balancing that can be done in favor of objections that have been lodged to the introduction of the boards. Certainly it's one thing for these boards and these photographs to be displayed in an academic setting, if you will, such that there can be some reference to the testimony and in some manner give life to the words and a visual reflection and description of the wound. I think, however, that the ends of justice would be better served by excluding those photographs and not allowing them to be displayed into the jury room. There is a legitimate concern that the overwhelming horror of
I gotta
the
go.
photographs
I'll be right
when
back.
placed in a small room
I don't want to go.
that the jury will be deliberating might take some unfair resonance and might serve to make it difficult to recall the nature of the testimony as it concerned the wounds. They are going to have the boards with them to which there were no objections. They are going to have the diagrams with them to which there are no objections, both in a small, compact version and expanded and enlarged. And I do think that when there is a fair balancing of the concerns, given the value of hindsight and recognizing that there was legitimate concern with even the placement of those boards and the proximity of those photographs to some of the seated jurors, that the natural extension of those concerns would follow into allowing those photographs into the jury room, and I urge the court to exclude the introduction of those boards into evidence. Exhibits 358A and 358B, if the court will recall, are very graphic and disturbing close-ups of wounds, one of Ms. Brown-Simpson and one of Mr. Goldman. There was strenuous objection at that time by Mr. Shapiro. The court considered those graphic photographs with some consideration and required some portions of one of the photographs to be excised. I would ask the court to go one step better and to disallow the introduction of those photographs into evidence. I've spoken already, Your Honor, about the defense's objection to Exhibit 407. The last exhibit would be Exhibit 411, which was
All right, those have
withdrawn.
been withdrawn.
Very well. If the court has no other questions, I'll take a seat.
All right. Thank you, Mr. Douglas. Good morning, Mr. Darden.
Good morning, Your Honor. Your Honor, the individual prosecutors that introduced each of the items of evidence that the defense is now objecting to will be speaking to the issue of admissibility on each of those items. I, however, have Exhibits 8, 9 through 11, 14 through 15, 14 through 15. As for Exhibit number 8, the lesson plan, this was the lesson plan that Ron Shipp used while he was an instructor at the LAPD Police Academy. It is the same lesson plan that he Xeroxed, took to Nicole Brown, discussed with her and showed to her. She then asked Ship to take it to the defendant and to discuss the batterer's profile as contained in that document with the defendant. Ron Ship did that. He testified to having done that. He testified to having gone over each of the indicators, or each of the elements of the batterer's profile with the defendant, and he testified that when he reached a point in the profile regarding pathological jealousy, that the defendant indicated to him, or stated to him, rather, that he, the defendant, was a little bit pathologically jealous. That testimony is contained on pages 12,748 through 50. As for the photographs marked 9 through 11, the relevant testimony relating to those photographs can be found at pages 13,282 through 4 and 13,309 through 10. Denise Brown testified that she took exhibits 10 and 11. So she took those photographs herself after the 1989 incident. She identified those photographs. They were placed on the Alamo before the jury, and there was testimony about those photographs.
All right, that was as to 10 and 11.
It's 13,282 through 4 and 13,309 through 10. Then there was the other photograph. I believe it's People's 9,
Yes.
which I will withdraw. I believe that's the photograph of Miss Brown, approximately 19 or 20 years old.
Yes, it is. She appears to be a younger age
But
than in
injured.
photographs 10 and 11.
Okay.
And you are withdrawing that.
Yes. People's 14 through 15, 14 and 15, those are the photographs that depict the defendant and Ron Ship on a movie set, as I recall. The defense raised the issue that Mr. Ship and the defendant were not very good friends at all, and that they had not spent much time together, and so the prosecution introduced a series of photographs depicting the defendant and Ron Ship doing various things. 14 and 15 were shown to the witness, and testimony
My
was given.
recollection is that I did not allow 13 because it depicts Mr. Simpson handcuffed in a theatrical situation.
Okay.
Okay.
I thought that the objection was to 14 and 15.
No, my recollection is that during the course of the testimony, I sustained the objection to that photograph being shown to the jury, is my recollection.
Okay.
But I do have before me 14, which appears to be a 4x6 photo of Mr. Simpson and Mr. Ship, apparently at some social function, appears to be at the defendant's house. And 14 is a smaller photograph, which appears to have Mr. Simpson with his arm around Mr. Ship.
Your Honor, that's my mistake that I meant to lodge the objection to the handcuffing in particular. That's my mistake.
All right.
Okay, and that's why I wasn't speaking to item 13 rather, because there had been no objection. At any event, I will withdraw 13.
All right.
Okay.
13 being withdrawn.
Okay. 14 and 15, as I indicated, the relevant testimony is at pages 12, 9, 6, 6, and 6, 7, and there was testimony by the witness.
I might own a computer real quick here. All right, 12966.
And 6, 7.
All right.
There's also People's 124, Your Honor, which is the video. While I'm up, I thought I should mention this. That is the video of the defendant handcuffed and the release of the handcuffs by Detective Van Adder. I am not seeking to introduce that video into evidence at this time.
We want it in there.
Well, we'll take that up as soon as we finish that.
Okay. At any event, those are the only exhibits that I'm here this morning to address, Your Honor.
All right, thank you. Ms. Clark, good morning.
Good morning. I think the only exhibits the defense is objecting to, of the ones that I marked, are 132 through 134. Concerning lack of foundation, with respect to those photographs, the foundation was laid. Let me cite the court to the transcript, pages 19815 to 19819. Beginning with Brian Kalin testifying in response to the following question. Do you know what the contents of the garage were or what the garage looked like inside as of June the 12th, 1994? Answer if something's okay. Question, okay? Sorry. If I show you a photograph of the interior of that garage, will you be able to tell us whether it fits your memory of the appearance of that location? We then proceed to mark the photographs and go through them one by one, and he authenticates as indicated in the photographs, and all of them were authenticated by him as items he recalls in the garage in the locations in which depicted as of June the 12th, 1994. And I believe that's all the foundation that's needed for that. May I also address the court with respect to exhibits I think should be withdrawn at this time? Or do you want me to wait?
Let's just do the ones that are being contested at this point.
Okay. Actually, Your Honor, I mean, if the court prefers, we can wait to withdraw exhibits till the end of the case. So, whatever the court prefers.
Well, let's take up the ones that there are objections raised at this point.
Fine.
All right, then when we conclude this discussion, then we'll take up what you want to withdraw.
Okay.
Right.
So that's that. And I think Mr. Kelber, I think now we'll get out of the way.
Mr. Kelberg, are you responsible for the cart being here today?
I am not, Your Honor, and once again, people have accused me unjustifiably. And anybody who saw my materials know that I use yellow pads with red and blue ink, and I don't rely too frequently on green binders, except I have the exhibit list provided for me. And raggedy boxes. That's the most telltale circumstantial evidence that I've been around. Again, Your Honor, it's a pleasure to be down here to address the court. I think it is interesting that the largest volume of objections appears to be to the evidence that was provided through Dr. Lakshmanan, which may reflect not on the length of the examination, but the force of the evidence that was given the jury from Dr. Lakshmanan. Let me start. I didn't actually mark 43, 59, 59A, and 59B, but I gather by default I've been asked to comment on those because those are crime scene photographs, and they really fall into the same genre of photographs, in particular 354. Which is a board that has, I believe, at least one of the photographs, 43, on it. So I'd like to talk about those when I talk about the crime scene photographs. I would initially respond to Mr. Douglas's objection to Dr. Lakshmanan's curriculum vitae. I remind the court, although I doubt the court needs reminding, that 352 says that the probative value must be substantially outweighed by the prejudicial effect. I can see no prejudicial effect to having provided the jury a concise 9 or 10 page summary of Dr. Lakshmanan's qualifications. We did not go into every entry that is on his curriculum vitae, and in the event the defense produces Dr. Bodden and or Dr. Wolf, I assume that they will have their curriculum vitae marked, and the jury will have them to compare and contrast to see the relative experience, education, training, publications, and so forth. So from the standpoint of prejudice, it's difficult for me to understand how there is unfair prejudice. In fact, it helps the jury because it concisely provides the information.
I understood Mr. Douglas's argument, though, to be the second phrase of 352, that since we did go through a long and extensive testimony from the doctor regarding his many board certifications, and et cetera, that it's really redundant.
Well, it's not redundant if, for example, the jurors did not write down everything that was said, and the jury then has a question, and let's say, again, Dr. Bodden and or Dr. Wolf testifies, and the jurors are back there trying to decide, well, gee, do I want to rely on this expert versus that expert, and the jury instruction tells us that we should look at their qualifications, and I don't remember exactly what their qualifications were. Am I going to ask the court to have a readback of the relevant qualifications of the experts so that I'll have that information? If we give the jury the curriculum vitae of these experts, the jury has it available immediately, concisely, and quickly to go over and evaluate the relative merits. And again, I would have no objection to the curriculum vitae of any defense expert being marked and received as an exhibit, because I think it helps the jury, it saves time, and it is not cumulative because no one goes over everything that is in a curriculum vitae, in particular publications. It's summarized by number and type, but not in the detail that the curriculum vitae provides. So understanding the objection as the court understands the objection, I still believe it is not well taken. With respect to the knives, Mr. Douglas may not recall the testimony, but the thrust, probably a bad word, the tenor of the testimony regarding those other knives deals with class characteristics of knives and to differentiate how knives, for example, there are single-edged knives, there are several of them presented, but they have different lengths, they have different widths and different thicknesses, which go into how wounds can be different in appearance when inflicted by different kinds of knives. One of the knives is a double-edged knife, which I believe is Exhibit 335. If I, let me get my little cheat sheet here if I could for a second.
Well, I have them here before me.
Yes, 335 we have marked as the double-edged knife, which is to show the different characteristics that knife has from a single-edged knife. The other knives are different types of single-edged knives to give the jury an understanding. Again, under 352, we have never suggested, in fact, I think we made it clear to the jury, these are not knives that we suggest in any way were involved in this case. We have in no way tried to suggest that Mr. Simpson is connected to any of these knives. These were offered for a specific purpose. Mr. Shapiro objected at the time, made his argument to the court. I believe he even renewed the argument a second time regarding the knives. The court overruled those objections. I see no basis to change the court's ruling at this time. They were offered for a limited purpose. That was the purpose they were used for, and that is the purpose for which they should be received. And clearly they're not going to go into the jury deliberation room unless the jury, I would assume, makes a request for them, and then they would have them under some sort of supervision. So the concern that they might injure themselves, I think, is not well taken. Jurors in many, many cases have received weapons of various types, and to my knowledge have come through unscathed from the experience. Let me then talk about 337. In fact, the lines of Langer were discussed by Dr. Lakshman. In fact, the court may recall we had a little refresher course in geometry. I think I used the term trigonometry with Mr. Fairtlow, whose artistic success in drawing a right angle was put in some question. But that page showing the lines of Langer was used by Dr. Lakshmanan to explain how wounds can become gaping wounds rather than very narrow wounds that one might expect from a incised type of knife wound. And clearly there are a number of gaping wounds that were received by the victims in this case. We are then left with the photo boards. And actually the list that I have, which is a handwritten list, and I don't know if this was faxed to us or somebody got the information and wrote it down, somebody within our office. So the list I have, for example, does not include board 358. It has 358A and B, but I understand 358 to be a board, and I'm sure that Mr. Douglas is objecting to that board, and I take his objection to be basically to all the coroner photographs.
No, the list that is before the court does include 358 and 358A and B.
Okay. First of all, the court has already sustained the objection to 358A, and Mr. Douglas is mistaken as to what that photograph is. The court may recall that we presented, I think, 3 photographs to the court for its consideration in a 402 ruling in the middle of Dr. Lakshmanan's testimony. These are photographs, all of Mr. Goldman, all taken at the scene, all demonstrating the area of the front of his neck with respect to those 2 superficial incised wounds, which I think are shown in photograph G37 of the board, which is 358, I believe. The court sustained a 352 objection to the use of the first photograph, which was 358A. So we don't quarrel with the objection having been sustained. It's sustained and that photograph's not being received in evidence. We understand that. 358B, the court ruled that the probative value did in fact outweigh the prejudicial effect, but the court did order that the photograph be cropped. The photograph was cropped, and that is what the jury should receive. Now, I think it's important to remember, at least as I listened yesterday on the radio, that the court has already heard Mr. Cochran's renewed motion under 352 to exhibits 354, 358B, and 359. As part of the stipulations regarding those photographs, Mr. Cochran, to preserve the record, renewed the 352 objection. The court basically said it stands by its ruling, and unless there's something that I miss, I don't see any basis to have a change between yesterday and today in the court's ruling. If the court wishes me to address those exhibits, I will, but for the reasons that the court expressed, nothing's changed. If anything, the evidence takes on even stronger importance, more critical importance for the jury's understanding now, because it fits the circumstances of these 2 murders together, along with the hair and trace evidence which was presented through Mr. Diederich's testimony as our last witness. These photographs have compelling probative value. The court found that initially, and there's no basis to say that that probative value has in any way been undermined. It ties the case together. There is no chart, there are no words that can convey what those photographs convey. No one said they would be pleasant to look at, but that's not the job of this jury. This jury's job is to look at evidence that is probative and will help this jury one way or the other decide this case. The court found that these would be helpful photographs, and I believe that through Dr. Lakshmanan's testimony, that of Mr. Diederich, the jury has a very good understanding of why they are important. And it'll be a matter of argument, perhaps, for the counsel on both sides to suggest to the jury whether they are important or they aren't important, but from my view of what the jury paid attention to during the course of the time that I did a very lengthy direct examination, that jury paid attention. And although they may be disturbing photographs to some extent, as they should be disturbing photographs, they are not disturbing in a way that the law says keeps them from being considered. These photographs show what happened to these two people. These photographs show premeditation. They show deliberation. They show express malice. They show one person with the power to murder two human beings could accomplish that. They explain the wounds, for example, to the back of Mr. Goldman's hands as not being caused by a blow to the perpetrator's face. And so any theory on that line suggested by the defense is, I think, quite nicely undermined by the photograph and, of course, Dr. Lakshmanan's testimony. They show all of these issues that are relevant to the jury's consideration. They also show the blood that will be caused to flow and which can justify why the shoe prints are there for 86 feet to the end of that walkway at the back of the property. All of these factors, Your Honor, are factors that the jury will have to consider in saying, is this the man who murdered these two people? Have we proved it beyond a reasonable doubt? And if we have proved the identity beyond a reasonable doubt, is it a first-degree murder or a second-degree murder with respect to each of these two cases? So with respect to those photos, I suggest to the court that their value was demonstrated when the court, after a very lengthy consideration and then lengthy argument from both sides, ruled that these photographs should be seen by the jury. And nothing has changed. If anything, all that's been changed is to understand even more so their importance. And I think that's what the court indicated yesterday when it overruled Mr. Cochran's renewed 352 objections. So unless the court has any questions for me with respect to this group of photos, and I include really 43, 59, 59A, and 59B, I will sit down and hopefully not to be heard from again unless dragged in by Ms. Clark or Mr. Darden to do a little cross-examination.
All right, my recollection, the photograph obviously that troubled the court the most in this entire sequence was that of 358B, which was the photograph of Mr. Goldman at the scene. And my recollection is that the issue was it an ante-mortem? Were these the incised superficial wounds ante-mortem? The issue being, was there evidence of bleeding into the tissue at the crime scene?
Exactly, Your Honor.
Okay.
Anything further you wish from me, Your Honor?
No, thank you.
You're welcome.
May I address the court, Your Honor, with respect to, there are additional issues with respect to 43, 59, 59A and B, and I hope that Mr. Kelberg can be invited back into the courtroom as opposed to being dragged back in. But with respect to those photographs, Your Honor, 43 not only is illustrative for the purposes of the coroner in terms of where the bodies were found, but is illustrative of Robert Risky's testimony concerning the positions in which the bodies were found, the lighting in the location, and the location of evidence as he found it. And so the condition of the scene as found by each of the officers is relevant to all of the inquiries concerning where everything was in relationship to each other, issues of surprise. Ron Goldman hadn't been taken by surprise. The keys dropped in one location, the pager in another. The lighting and what officers could or could not see, and therefore, by inference, what the defendant could or could not see, and thus left behind in his haste to get away from the crime scene. All of these issues are illuminated, no pun intended there either, considerably by the photographs that show the location of the items as they were found by the first officer at the scene. If I could briefly look at 59, 59A and B, I think the court has them on the bench. The court will recall that 43 was the board marshal officer Risky of the victim at the crime scene.
59A and B. In fact, let me give you the whole series of photographs in that series.
As far as I know, as far as I can tell by the list proffered by the defense, it's only of this series 59 and 59A and B that are objected to. The board and this series, this 43 series is not an issue. The only objection I have in front of me, according to what the defense has proffered, is 43, the board. If the court will recall, there was considerable testimony and cross-examination about the location of items of evidence and where they were in relation to the bodies of the victims, and subsequently whether they had been moved, and if so, how much. The photographs in 59 and 59A and B show the view of the victim in place as seen by Officer Phillips, Detective Phillips, and is therefore relevant to show the position of the body when the detectives arrived. And his testimony illuminates that further. And you can see that on 59B, the initials RP are shown. It's also shown in these photographs. The testimony went to explain what the officer could see from various positions around the body of the victim. And those zoom-ins, which are shown in 59 and 59A and B, are important because they focus specifically on what the officer was talking about in terms of what he was able to see from where he stood around the bodies of the victims at the Bundy location. So obviously there is great probative value. The prejudicial value is virtually nil. The photographs shown there are neither particularly gory or gruesome in any way or shape or form, especially in light of other photographs that had been received by the court, but they are very informative in terms of the ability of what can be seen from various positions. And if you recall, with respect to the issue of contamination of a crime scene, the officers were careful to stand just outside the gate and then to walk around behind, over to the north side of the gate in order to see into the crime scene, purposely avoiding stepping through the crime scene as much as possible. So those positions and those views are very important to illustrate the measures taken to avoid contamination of the crime scene. So for all of those reasons, we have great probative value with very little, if any, prejudicial value in view of all of the evidence that is coming before this jury in another manner. With respect to 75 and 76, Your Honor, the photographs of the knife on the table,
Yes.
the issue raised here is relevance. Frankly, Your Honor, I think it could be very probative. And let me explain this. We have a very clean kitchen with nothing out of place, except this big butcher knife lying on the countertop. I think it doesn't take a great leap to infer that Nicole heard someone coming up from the rear, as opposed to from the front. She knew that Ronald Goldman was coming to the front to return the glasses, and if he had, and when he did, he obviously had to ring the bell. He obviously had to ring the buzzer in order to get in. That would not have caused her fear or concern. But someone coming up from the rear, where no one should be at that time of night, would have. And so she might have armed herself, hearing the sounds of someone coming up from the rear, only then to put the knife down when she realized that perhaps no one was there as Mr. Simpson hid. And having heard nothing further, no further sounds, put the knife down and went out to let in Ronald Goldman, who had just rung the bell, only to then be surprised by the fact that indeed someone was there. So I think that this knife has great probative value, and the fact that it lies out there alone in a very clean and orderly kitchen, I think is highly significant. So I think the relevance is demonstrated by that argument alone. And I'll leave it with that. With respect to 43, does the court wish to have it brought out so I can
Yes.
point out?
And Mr. Farrell, I want you to set the easel up over there. Dog, put the... All right, as to 43.
It's been a long time, I know, but the court may recall that the view of the crime scene by both police officers and by civilians and what they were able to see from various points on the sidewalk was extremely important, and I suspect may become even more important when we begin the defense case. These photographs were authenticated not only by Robert Risky, who was the first officer on the scene, but also Sukru Bastepi, who was the first person to see the body and have the police called in order to have the crime scene taken care of. And these photographs and the appearance of the walkway from the sidewalk is extremely important for many reasons. Number one, it shows what could or could not be seen in the dark, how dark the area was and the placement of the victim. It also shows the lack of any shoe prints going down the walkway to the sidewalk, which is obviously important, both from the standpoint of proving that one person did it, as well as establishing that the only escape route could have been down the walkway to the west, where we have the bloody shoe prints and the blood drops. This photograph 43C, as authenticated by Robert Risky, demonstrates clearly the position of the body as first seen, as first found by him, with her legs underneath the gate, which I think will be extremely important. And this 43D shows the placement of the envelope next to, in juxtaposition between the two bodies, that is Nicole and Ronald Goldman, And that's important. These two photographs, 43D and E, are important next to each other. We have no photograph in which the bodies of both victims with the evidence between them is depicted in one photograph. We've had to put two together or three together in order to give the jury a view of all of the evidence in its relationship to the victims. And as I pointed out earlier, the location of all of that evidence in relation to the victims is very probative to demonstrate how they were taken by surprise and demonstrate how evidence could have been dropped, like the hat and the bloody glove, by the defendant without being able to later locate it to take it away with him. And these photographs are extremely illustrative of all the issues that I've indicated, as well as the issues pointed out by Mr. Kelberg concerning the area in which Ronald Goldman was basically pinned by the defendant, the location in which he was basically caged, hemmed in, and unable to run, and it demonstrates that very well in 43E and F. Not to mention the location of shrubbery and shoots and branches on which he was, on which his hands were cut in the flailing motions in an effort to get away from the defendant. So I would submit that the probative value of these photographs highly outweighs any prejudicial value, and it's illustrated by the testimony of not only civilians and officers, but the coroner as well. Can I have more, John?
Yes.
Also, 75 and 76, Your Honor, the kitchen with the butcher knife on the counter, Mr. Kelberg points out a very good point, which is that if the defense wished to contend that Ms. Brown ate again after she came home from Ben & Jerry's, that very clean kitchen with no evidence of any food in sight would be further evidence to demonstrate the fact that the stomach contents that were viewed during her autopsy could only have come from the meal she had at the Mezzaluna for the purpose of fixing the time when she last ate. And that could very well become an issue if Dr. Bodden does take the witness stand. So there's a further reason for that.
All right. All right, anything else, Ms. Clark?
I think that we've addressed it all now, Your Honor.
All right. Mr. Douglas, do you wish to have any brief response?
Your Honor, the crime scene photographs create prejudice from the collective impact of the sheer number of photographs that the prosecution is seeking to introduce. As I said in my preliminary comments, we recognize that this is a murder case, and with all murder cases, there are gory photographs. The concept of a gory photograph per se, we do not have an objection to. However, there is indeed some sort of psychic impact of continuing to display repeated photographs that we think are cumulative and are not necessary. Let them show four photographs of Nicole Brown Simpson that adequately shows the items and the correlation and the relationship between the bodies and pieces of evidence that they want to show. Let them pick out the best four. Let them show 3 photographs of Mr. Goldman that would adequately reflect the correlation between the fencing and the gloves and the shrubbery. But there is, we believe, a real danger of bombarding the jury with countless numbers of photographs, all that seem to show a minute distinction between the other. And I think collectively there is a colorable basis for an argument that they are cumulative and that they all are not unnecessary. They all are not necessary. As to the discussion of the weapons and the 4 knives, if you will, that Mr. Kelberg showed to Mr. Lakshmanan, we believe, Your Honor, that the education boards, which I recall a board specifically talking about single-edged and double-edged knives, single-edged and double-edged wounds, the distinction, the corollary, the relationship between both, there was fine attention made and given to those sorts of differences in the knives. Nothing is added, I argue, to having those actual knives introduced into evidence, given the state of the record that there is no indication that this sort of knife created the wound, that this is something of more probative value than simply having show a particular knife. The jury has now been able to appreciate the value that the people sought by introducing that knife for identification. If there was an objection lodged, the court ruled, and for identification, such as a demonstrative board or a demonstrative piece of evidence that has now shown and exhausted its usefulness. Mr. Kelberg realizes and recognizes indeed that the actual knife would never be allowed to be brought into the jury unless accompanied by some juror attendant or bailiff. Therefore, there's no real need to have those particular knives introduced. As to the argument concerning Exhibits 75 and 76, it was a creative bit of lawyering, I'll give Ms. Clark credit, seeking to pull from the air some colorable argument for why a particular photograph is relevant. But I do not think, Your Honor, with all due respect, that rank speculation should ever provide the basis for relevance or should be a substitution for relevance, particularly given this record where there is no evidence whatsoever that gives any insight into Ms. Brown Simpson's actions that night after the phone call from her mother, Juditha Brown. Unless the court has any other questions, I'll submit the matter.
All right, thank you, counsel. All right, as to item number 8, which is the lesson plan that was testified to by Mr. Shipp, I'm going to take that objection under submission. I want to review the transcript because I don't have a clear recollection in my mind as to what Mr. Shipp said about that. As to number 9, that is withdrawn. As to 10 and 11, the court's recollection is similar to Mr. Darden's, that Denise Brown did testify that she did in fact take those Polaroid photos, and I believe that there was a sufficient foundation laid for that. Those two photographs, the objection on those will be overruled. Court's ruling on number 13, sustaining the objection, will remain. As to 14 and 15, those photographs are relevant to the nature of the relationship between Mr. Shipp and Mr. Simpson. There was a foundation laid. Objection will be overruled. As to 43, the board, the interesting thing is that there is no overall photograph available that depicts each of these items and their relative location. And the position of items is critical both to the defense and to the prosecution as to their relative positions, whether anything was moved. There is no other source of information other than this series of photographs, each one depicting something that is unique to that photograph, which is relevant to the case. So I will overrule the objection to that as well. As to 59, A and B, the objection was previously sustained to 59, I'm sorry. All right, as to 59 and 59A and B, the objections, court's ruling previously will stand, the objections will be overruled. As to 75 and 76, which are the photographs of the kitchen at Bundy and the close-up of the what appears to be a butcher knife on the island counter, what that indicated to the court was, one, it was a very clean kitchen. Two, that there was no disorder in the condo itself. There was an issue as to whether or not any of the assault had taken place inside the Bundy residence. There was testimony regarding whether or not there was any discoloration in the carpeting, whether or not there were any apparent footprints, any blood that was tracked into the Bundy condo. And to the court's recollection, these are the only two photographs that exist of anything in the interior. It goes to the nature of the investigation, good and bad, the fact that these are the only two photographs taken. We have no photographs of the entry-exit in the garage. We have no photographs of the interior of the living room. I think there is significant probative value, and the objection will be overruled. As to 132, 133, 134, these are the photographs of the garage. The court's recollection is that Mr. Kalin did, in fact, testify to the items that are depicted there, the interior of the garage. Court also notes that this was one of the items that was on the jurors' visit itinerary, and that the jurors did themselves look into and examine the garage and its contents. I believe there's a sufficient foundation, and the objection to those will be overruled. As to 334, 335, the knives that were used by Mr. Kelberg for demonstration purposes, the demonstration boards that depict single-edged, double-edged knives are two-dimensional. The knives themselves are three-dimensional. They are for the purpose of demonstrating class characteristics only, which I think are important to see in 3 dimensions. So the objection will be overruled. As to 337, the lines of Langer, this is an interesting concept in explaining why wounds appear as they do. something that a layperson doesn't ordinarily consider or know about, I think its probative value is significant, and I will overrule the objection. As to 358A, the court will sustain the objection to that. As to 358B, court will overrule the objection, and that photograph is cropped as directed by the court. As to the overall category of the autopsy photographs, I'm sorry. Haven't gotten there yet. I was just about to flip the page. As to the autopsy photographs, which are 352, 354, 355, 358, 360, 361, and 362, the court previously had taken a considerable period of time to consider each and every one of the photographs that was submitted. And the court issued its ruling in written form previously, and as the court observed yesterday in discussing the matter again with Mr. Cochran, that those photographs now combined with the testimony of Dr. Lakshmanan take on additional meaning and probative value, and the objections under 352 renewed are again overruled. All right, Mr. Douglas? I'm sorry? No, I did not. 295 was Dr. Lakshmanan's resume, if I'm not mistaken, correct? And that objection will be overruled. All right, do we have anything that's left on that?
Your Honor, I think there was, Mr. Douglas objected to 359. I'm assuming the court is adopting his ruling from yesterday. That was one of the ones Mr. Cochran renewed his 352 objection to. Those are the photographs at the scene for the environmental sources for the blunt force trauma to the back of Mr. Goldman's hands and arms.
Was not one of the items raised today.
It was not. Oh,
Was
it's
not.
on my list. I'm sorry.
All right, next item of business. Ms. Clark, are you going to advise the court, or Mr. Darden, are you going to advise the court as to which of these exhibits you are going to be withdrawing, additional exhibits?
People would withdraw People's 54.
Which is, I show 54 as a poster board.
Oh, no, that was on my list to look at, excuse me, Your Honor. People would move to withdraw 66A, which is,
All right, 66A is a computer printout of a diagram of the Simpson residence with red markings.
and 69 is a transcript of the calls to the coroner's office by Detective Phillips. I believe that that transcript is just hearsay, and it was not capable of authentication in terms of accuracy because the transcript was not prepared by a certified reporter. In fact, there were, I think, indications even in the testimony to some inaccuracies. And 70, which is a police manual, release of information section, people will withdraw. 102, and with respect to that, the reason for withdrawing is the witness's testimony is what is in issue and what is important, rather than treatises, because the witness is not an expert. 102, the letter from Kathleen Bell to Detective Furman. Unless and until Ms. Bell testifies to authenticate that letter, I don't think that there is a foundation for its admission. It was to the defense, that letter, as I understand it. People's 124. Video taken of the defendant being handcuffed. People's 144, four-page statement taken by the police of Mr. Kamen, the hearsay document. I do not see the relevance in light of the fact that the witness testified at some length to his recollection of the relevant events in this case. And then I believe that 158 and 159, Your Honor, were marked only for motions, but they are crime scene logs for Rockingham. And they were not marked for the purpose of admission into evidence before the jury. I just want to point that out. Also, we're also going to withdraw 363, which was the primetime live tape, because in its place we are asking to admit 363A, which is the redacted version of the same. And then one more, John? And I would proffer to the court again my previous offer that we can really handle this perhaps better at the conclusion of the case for both sides. I compiled this list this morning in case the court wanted to address this now, but if the court would prefer not to.
All right, Mr.
Or Ms. Lewis reminded me, without prejudice, we could move to withdraw at a later time, that this is not the final say in terms of what we seek to withdraw.
One difficulty, Your Honor, as the court will soon learn, is many, if not most, of the exhibits which the people may seek to withdraw, the defense will seek to introduce. Therefore, if there's going to be documents to be withdrawn, we need to know now, so that if there's a problem with further foundation or whatever, we can then call those witnesses to lay the proper foundation and not be forced at the very end of the case to have an inadequate record. So there's great prudence and reason for having those choices and decisions made at this point.
Well, my understanding of what just occurred is that Ms. Clark is indicating to the court which prosecution exhibits they wish to withdraw, and they're giving the court and defense the option to either address the issue now or at the conclusion of the case.
Very well.
But since you have this list now, you can have the opportunity to look at the exhibits themselves, examine the record yourself to see if there's a sufficient foundation. A couple of these obviously are questionable because of their nature.
Okay. As to 66A, we have no objection.
All right.
To it being withdrawn. As to 69, which is the transcript of the telephone call from Mr. Phillips to the coroner's office, we would seek to introduce. We do think that the jury does have the benefit as well of the actual tape recording. We think that there are sufficient guarantees of trustworthiness such that there can be no reasonable hearsay objection to that document.
Well, Mr. Douglas, my preference at this point would be this list is to put you and the court on notice as to what the prosecution doesn't intend to offer at the conclusion of the case in total.
So the court would rather us wait until...
Yes, because some of these may not even be relevant by the end of the case.
Your Honor, we would like to move our exhibits into evidence so that we will then know at this point if there is, for example, at this stage, a foundational objection, an authentication objection. At this point, as we begin our case, we will then be prepared to combat and to respond to those sorts of objections, such as foundation or authentication. We will have the witnesses available, and there is, I think, benefit to the process to have those questions resolved at this point.
All right, Ms. Clark, any response to that?
Your Honor, I guess Mr. Douglas was not here, but we agreed yesterday in chambers that we would not be doing that today, and of course the people relied on that, so you can handle
Pick
it.
it up Monday morning.
No. How many exhibits do you have? My recollection is we've got a couple hundred defense exhibits at this point.
Your Honor, we have 224. Can we do it, Your Honor, the first available opportunity, like a Friday afternoon, perhaps?
I think our Fridays are booked for the rest of the month.
Can we do it 8:30 Monday morning so that we're not taking time from the jury? I will be here at 8 o'clock before business.
Well, I don't think at this point the prosecution is under an obligation to tell you what their objections are.
Well, Your Honor, certainly with regard to the prosecution exhibits that they don't wish to introduce, we should then be able to give them notice, if you will, and to give the court notice that we seek to introduce them.
And they've
Have a
given,
ruling on those matters.
and they've now given you a list of those they wish to withdraw.
And I would like to tell the court which of those we'd like to introduce. Can I do that?
Yes.
Very well. We seek to introduce Exhibit 69, 70, Exhibit 102. We'll lay the foundation by calling the witness. Exhibit 124 is central to our claim that there was a premature rush to judgment, and we seek to introduce that. We think that there has been a proper foundation laid at this point. Exhibit 144, we seek to introduce. I find it curious that the people would even introduce a document which they would believe to be hearsay. We think that there has been an adequate foundation laid, and that it is not hearsay, if offered by the defense. Exhibits 158 and 159, there was an adequate foundation laid by Detective Looper. If offered by the defense, it is not hearsay. We seek to introduce both of those. The crime scene logs were both introduced. We'll lay the foundation for those documents, Your Honor.
And 363A. 363, 363A.
One moment, please.
That was the videotape of Dr. Golden.
Submit matter.
Submitted? Okay. Alrighty. Anything else?
A couple of items, Your Honor. With regard to discovery, the defense, of course, has given us 8 or 9 names of individuals they expect to call on Monday.
My recollection is Mr. Douglas at the beginning of his comments indicated that he was going to turn over at the first break a number of statements, et cetera, to you.
Okay. There's still the 3-day rule, however. We should be entitled to a list of witnesses beyond Monday at this point. In addition, we have lodged objections to a number of the witnesses that they intend to call on Monday, which I expect will take some time away from the jury to resolve.
All right, you've lodged what objections?
You know, Mr. Yokelson just filed it, and I do not have the P's and A's here in front of me, but we
It's been filed with the court?
they've been filed with the court. We have objections.
All right, I haven't seen what it was filed.
At any event, I suspect that that there won't be much testimony taken Monday. I think our objections are well taken as to some of those individuals. At any event, I'd like the witness list for Tuesday and Wednesday, and I'd like the order of witnesses for Monday, which I believe yesterday Mr. Coughlin indicated he would provide to me. I suppose that's another issue for Mr. Coughlin.
No, let's take them up one at a time.
One at a time?
Cochran.
Your Honor, with regard to this, we have last Wednesday given the prosecution a list of the witnesses we expected to call as the exact order. Before we leave today, I'll talk to Mr. Darden about that. First of all, this motion they filed, apparently they haven't looked at their own witness list. Mr. Douglas, if they look at the witness list that they were given on March 1st, 1995, we had the names Mary Collins, Carol Connor, and Sidney Simpson. They've been given those names back in March. There are no reports regarding those 2 witnesses, and what I told the prosecution, for certain of these witnesses, there are absolutely no reports. We've had no investigator talk to them, and I will share with them. We have a rule that we've all agreed upon, lawyers' notes. We don't turn over if there's any lawyers' notes or lawyers' reports. And with regard, there are no reports regarding the first 2. As to Bender and McKay, they have apparently interviewed those witnesses themselves. They've interviewed Kristen Reichart, and I can represent to the court that regarding Arnell Simpson, Carmelita Durio, and Eunice Simpson, there are no reports. Those are the defendant's mother, Mr. Simpson's mother, his daughter, and his sister. And so what the prosecution would like to do, as usual, is to get inside our heads and the defense's head. They've been trying to do that from the beginning. And basically, these are witnesses. I've given the witnesses, and there are no reports. What else is there to give them at this point? And I think that's fairly clear. As to the order, I'll be glad to give him the order. But these other witnesses, Connor and Collins, have been on their list since March. So I've indicated to them that I would speak with them and tell them what I expect the witnesses to go into. This whole idea of a 352 or a offer of proof for every witness is preposterous. I mean, we've been trying cases for a long time. We know it's relevant, and I'm sure Your Honor will guide us appropriately. We don't want to delay this trial. We want this case to be over as soon as possible. We don't want to take, I promise you we will not take 8 days on the direct examination of any witness. I promise you that. I promise our direct will be much quicker, and we'll get this case over. And we don't want to delay with a lot of motions. I mean, and we will give the prosecution a list that will stand and will not change like every day. And I remind the court that Mr. Darden had given me a list of 5 domestic discord witnesses, like in the morning. And later that morning, Ms. Clark says, we're not calling any of those witnesses. And I had all my books here and everything. We're going to try to give witnesses, stick by it, and go forward. I don't want to have any delays.
All right, so you will provide Mr. Darden with your order of witnesses for the
Yes,
first 3 days?
I will definitely do it. And further, I will do something I'm not even required to do. I'll talk to him about what I expect the witnesses to generally say.
There's no reports, but there are no reports with regard to the others. And as to Christian Reichard, for someone to stand here and say that on this report that Reichard his testimony is irrelevant material, Mr. Reichard is the man who had ended a relationship which he had precipitated with Faye Resnick, who knows about her the intervention on June 8th. He knows that she moved into Nicole Brown Simpson's residence, that she was so involved with drugs on June 8th that they had to have an intervention and put her in this drug treatment place. He is very relevant with regard to also the events of the 12th. So I don't want to go into all this, but we are quite aware of what is relevant. And so we have a right to put on, we don't have to put on any case at all. But we choose to put on a case, we don't need their advice. We're not asking them what we should put on. We want to do what's right under the evidence, and I'm sure you'll hold us to that, and we'll do that. We want to move through this case. We don't want these delays every minute. We know we know what we have to establish, and we'll do that and get out. There's one other thing while I'm here, if I might, Your Honor. We would like, at this time, to ask through the people to make Sidney Simpson available for interview, and although we would certainly not want to have her testify, there's certain very, very relevant testimony that she has to offer, and I would ask to be able to talk to her in the alternative with Ms. Clark to perhaps enter into a stipulation like we did yesterday with Mrs. Brown. It has to do with the remarks that were made at the police station in the early morning hours of June 13th, wherein she indicated that she had heard her mommy talking to her mommy's best friend and were crying after that conversation, and we think that's very relevant. And we would like to, put on those, we'd like to have that conversation with Sidney Simpson, and would hopefully down the road we can work and obviate the necessity of calling if at all possible. I'll make every effort to do that if they're willing to do it. Yes, we agree on that.
May I quickly refer to just a couple things on my exhibit list descriptions are not as sharp as they should be, and with respect to 54 and 66A, those are just diagrams that may be illustrative. I can see why the defense would not object. It probably helps on both sides, and so I would ask to withdraw my request to withdraw just with respect to those two items. 54 and 66A, they're just diagrams.
Your Honor, with regard to the witness list that Mr. Cochran was kind enough to hand to me, this is not our witness list. This is the defense witness list. As for Mr. Reichardt's testimony, we provided the court with a transcript of the interview we did with Christian Reichardt. His testimony in this case is irrelevant. The issue of Faye Resnick is irrelevant to these proceedings, and if Mr. Reichardt has information regarding June 12th, it is information that I do not have, and we are seeking from the defense an offer of proof, and I think we have every right to an offer of proof. And as far as this practice of interviewing witnesses, not taking notes, not allowing defense investigators apparently to interview the witnesses, or any alternative, allowing their investigators to interview witnesses and then not taking notes and not preparing statements is more than objectionable, I think. I think that if the defense is interested in seeking the truth, as they so often claim that they are, you would think that they would prepare notes to provide the prosecution with the discovery that we're due and entitled to. At any event, we have a right to an offer of proof, and we insist on that.
Well, how about Collins and Connor? What are these people going to testify to?
Good question.
Is he going to answer, Your Honor? You're asking about me?
I'm asking.
Okay, thank you. I'll address Your Honor.
Since they're names that have not come up before.
Their names that are on the witness list, as I indicated to the court, and they've been there because I know they're on there because each day when we change the witness list, the press immediately asks us about when we put Sidney Simpson on. So we got a lot of calls around that time, which we don't want to call Sidney Simpson.
Interesting, but doesn't answer my question.
Right. No, I just wanted to point that out. But now to your question, Your Honor, with regard to those two, the two ladies that you're talking about, I think they're very, very relevant. Without previewing our defense, which we're not required to do, and I'm going to respond to Your Honor's question. These are, first of all, let's take the two names. Ms. Connor is a lady who attended I think it was a $25,000 a plate dinner and sat at a table just next to Mr. Simpson on the night of June 11th, 1994. She provided a picture that was taken of Mr. Simpson and Paula Barberi at that particular dinner. I think she'll be very relevant with regard to demeanor. She's been on the list. So we need a statement from her to know that. And with regard to Mary Collins, and we think the evidence will show, by the way, she does authenticate a photograph, which I think I used back at the opening with regard to Mr. Simpson on that Saturday night, the court will recall. And Mary Collins is a lady who is an interior designer, Your Honor. We expect to call her. Mr. Simpson met with her Tuesday of the week of the 12th, it would actually be the week of June 7th. It would be Tuesday, June the 8th, I guess it would be, or somewhere like that, 7th or 8th. And she's an interior designer. And he at that time met with her and made arrangements to have his entire bedroom redesigned and decorated. It has to do with the events of the week leading up to that this event. Entirely irrelevant. But as I said, they can't determine our case, Your Honor. We determine the case. And I think you're going to find, if I stand before you and say we got relevant witnesses, you know, they're not just making up witnesses.
Mr. Cochran, I understand that, but the problem is if you have no notes to turn over,
Yes?
then an offer of proof is in order here, just to see if it's relevant.
All right. Well, that's, I think, that the court was saying, I would be more than happy to comply with you. But I think the court should balance that with the fact that we'll have, as we go along, many of the witnesses with regard to timeline and things like that, they know they've interviewed more than we have. But certain witnesses, and the court was for a short time in the defense, it's not necessary to have, we don't have 250 investigators assigned, as the prosecution does, and the LAPD. So we have to do a lot of things ourselves over the phone. And some witnesses you don't take statements from because you move on. We've also been in trial, as the court is aware, since September 26th. Mr. Shapiro's been here since about June 15th. They've been on this case. And I've been involved since July 22nd. So that, some of these things you do by phone and it's not necessary. And my learned colleagues will find that out when they get in the defense side someday. That, you just move ahead. And we do have memories and we're going to do the right thing. And I'll share with them exactly what these witnesses expect to do when you suggest it's necessary.
All right.
We have one other motion to, Your Honor. That files.
Yes. All right, Ms. Lewis, good morning.
Thank you. Good morning, Your Honor. We want to make sure the defense understands we do not have 200 or anywhere near that investigators. And Ms. Clark has been working on this case since June 13th. Sorry, I have since July 21st. Mr. Darden's been here a long time as well. One thing that troubled me, by the way, if I'm considered, and I would be happy to be so considered, if I'm considered a learned colleague of Mr. Cochran's, I'd like him to know that I'm never going to be doing criminal defense work, so I guess I won't have the opportunity to find out what he indicated I might find out. But all of that aside, Your Honor, this morning the defense provided two lists, one that says withdrawn witnesses, the other which says alphabetized list, and which is presumably the rest of the universe, those witnesses whom they still may be calling. A cursory glance of these lists has already revealed that there are ambiguities which are significant with regard to 3 potential DNA expert-type witnesses, and we'd like those cleared up immediately. For example, Dr. John Gerdes, who's been the topic of various discussions, his name appears on neither the list of withdrawn witnesses nor on the list of witnesses they may still call.
Well, then I assume that means he won't be called as a witness.
He will be called for audit.
All right.
That's a mistake. Mr. Douglas just indicated that he would be called. There are also 2 witnesses who are on both lists. They are Dr. Seymour Geiser and Dr. Don Riley. They're both on the withdrawn list and the list of people they're going to call.
They're withdrawn.
They're both withdrawn. And, Your Honor, my final comment I want to make is that at this point in this trial, unlike Mr. Cochran's commentary, the defense is required to preview its case. I just want a reminder that we are operating under reciprocal discovery, and the whole reason for that is to ascertain the truth in a matter. We're not here for the defense to wait until the last minute to preview their defense. If this is a search for the truth, they should have no hesitation in immediately setting forth all of their witnesses' statements and what they would be saying.
Well, as you now know, I'm not reluctant to preclude evidence.
Yes, thank you.
All right. Okay,
On the issue of Connor and Collins, you want to take up the 352 issue Monday morning? Or?
Monday morning.
Okay, that's fine.
All right.
With regard to these witnesses, if I may, Your Honor.
Yes.
We have no bio information about these witnesses, where they live, a telephone number, anything. We might like to interview these witnesses. Would you kindly ask the defense to provide us with addresses and phone numbers?
All right. I'll direct Mr. Douglas to do that after we conclude this morning. All right, that's the 1118.1 motion that I have filed that was filed with the court yesterday. Mr. Cochran.
This morning, Your Honor, I think. Actually, it was filed this morning, but that's all right. Who's counting, Your Honor? With regard to this motion, Your Honor, this motion is submitted. Thank you very kindly.
Mr. Cochran is standing on the lengthy and detailed points and authorities he filed. I think it's the shortest motion I've ever seen, and the people will also submit it. Unless the court needs to hear from the people as to any particular issue, I see no reason to belabor this. Come on, Your Honor, please. Motion for discovery from the court. Do you want to be heard? Do you want us to be heard? I don't think that the court needs to hear from us, though.
All right. I believe at this point the prosecution has met the burden that's required at this point, so the motion be denied.
There's one last thing. Let me say one word to Ms. Clark. Thank you. May we approach first without the reporter at first?
Calls them with discretion.
All right.
We'll ask they not arrest these witnesses, Your Honor, also.
All right, Mr. Cochran, anything before we conclude this morning?
Yes, Your Honor. Yesterday, in Your Honor's statement regarding a pending jury matter, Your Honor indicated the interviews that you conducted. And it seems to me that last night and perhaps this morning, in seeing and watching the news, the press has now targeted the wrong juror. And it seems to me unfair to former juror number 2 that people have been camped out at her home, because I think the record should be clear that she is not the target of any misconduct or anything with regard to this latest thing. And I wanted to make that clear. I thought it was unfair to her, and somebody should speak up on it regarding that. And I spoke to Ms. Clark about it. Right. They have the wrong juror.
I had not seen any of the coverage, Ms. Clark.
No, I hadn't seen the coverage either, but I totally agree with Mr. Cochran that that was unfair.
All right.
May we make one request of the court that we be allowed to photograph again defense exhibit number 233. I mean, the defense exhibit concerning the blood vial, and it's been photographed as now in evidence of People's 233. We would like to take another photograph that would be a little clearer. Apparently that was kind of fuzzy. That would be acceptable, and then we would substitute that for the 233 exhibit.
All right, you can do that this afternoon.
Thank you, Your Honor.
All right, anything else? All right, we'll stand in recess, 9 o'clock Monday. All right, let me see Ms. Clark and Mr. Cochran. Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, Mr. Blazier. People represented by Ms. Clark, Mr. Darden, and Mr. Gordon. The jury is not present. Counsel, anything we need to take up before the defense calls their first witness? Good morning, Mr. Cochran.
Good morning, Your Honor. I just wanted to indicate for the record that yesterday at about 5 o'clock, I should start off by saying that I had received a call from Mr. Yokelson, I believe on Friday afternoon, regarding witnesses above the 8 or 9 names that I had given him, I think on last Wednesday, or the prosecution. And we did, in fact, get back to him yesterday afternoon and gave him perhaps 20, 24 additional names, which we think will perhaps take us through the next 2 weeks.
Which means we have approximately how many names at this point?
That I've given him probably somewhere, I haven't counted exactly, Your Honor, but somewhere in the area of about 30, 33, 34. And I would indicate further, is if there are witnesses we're not going to call when I become aware of that list, I'll let the prosecution know and try to always let them have the order. And I think that will expedite this matter so we can move through this trial. I do have some concerns, however, Your Honor, that I'd like to bring to the court's attention. One of our witnesses that we expect to call, hopefully today, depending on how fast we move, is a lady named Carol Connors. And this lady yesterday received a call from a lawyer by the name of Gloria Allred that was entirely inappropriate. First of all, Ms. Carol Connors is represented by a lawyer, and he will be here later today. His name is Ed Peace. I spoke with him last night. He was extremely upset that Ms. Allred would seek to call Ms. Connors, whom he represents, and then proceed to badger her, and was screaming at her to the extent, according to Ms. Connors, that Ms. Connors had to hang up the phone. And the reason I want to bring this to the court's attention, she was apparently urging Ms. Connors to talk to the prosecution. And I am very concerned for these number of witnesses we have that I don't want to see them harassed. Certainly the prosecution has a right to ask to talk to the witnesses. If the witnesses want to do that, that's fine. We have no problem with that. But I will not stand by as an officer of this court and not at least bring it to Your Honor's attention. And I believe Mr. Peace will be going to the other appropriate state agencies regarding the conduct of this lawyer in calling his client and badgering her like it happened last night. And I just wanted to put that out and put it on the record. I think that it was very unfortunate, and I hope that won't happen again with any of the other witnesses. It's in a search for truth, Your Honor. Witnesses should be able to come to court without fear from anyone or being intimidated or affected by anyone. And I think it would be outrageous if people were deterred from testifying in this case because of the conduct of any of the parties. And so I wanted to bring this to the court's attention.
All right. Thank you, counsel. I'll hear from Mr. Peace when he's available.
We will be here before she testifies, and I'm sure we'll bring it to Your Honor's attention. The other thing is that, as we've indicated to the court, in proceeding with this case, we're ready to proceed and would ask leave to call Ms. Arnell Simpson. We had a conversation back in chambers on Friday, in which I indicated the general parameters of her testimony. And if there is any area where I feel that there's a question or whatever, and there is an area where, regarding a letter that we gave the prosecution last evening, and this is a letter from Nicole Brown Simpson to Mr. Simpson in '93, which we think is very probative, but it has a specific purpose only. And before we get to that or ask any questions of it, I want to have a 402 hearing, but I don't want to delay the proceedings. That would be the very last question, and we would not, before we got to that, I would ask for a recess, and we'll have a 402 hearing. All right, that's all I would like to do.
All right. Good morning, Ms. Clark.
Good morning, Your Honor. Let me first indicate to the court, and assure the court, although it probably does not need the assurance, at no time have the prosecution engaged in any conduct that would tend to harass or intimidate anyone, any witness for either side. We have had no contact with Carol Connor. I certainly have never spoken to Gloria Allred, and if any of the allegations made by counsel are true, which I sincerely doubt, then that is a matter to be taken up at a later point, but it certainly does not involve any conduct on the part of the prosecution. We would never engage in such conduct. It's beyond even thinking. Secondly, Your Honor, with respect to the proposed testimony of Ms. Simpson, the people are requesting that there be an offer of proof. We have no statement from Ms. Simpson. We have no indication at all as to what the parameters of her testimony might be. The proffer of the letter back in '93, I believe, from Ms. Nicole Brown is an indication to me that the intended parameters are very, very broad and perhaps impermissible in light of the issues that are framed in this case. And rather than have to go through lengthy sidebars and objections that will waste the jury's time, we are asking that the defense be required to submit an offer of proof to this court so that we can see what the boundaries of the testimony proposed by her are. At this time, we have no idea. The only statement we have from Ms. Simpson at this time is very, very brief testimony elicited at the preliminary hearing pursuant to 1538.5 motion made by the defense at that time, which is July of '94. At this time, there's been no statement made by her to the officers. There's been no statement made by her to the defense, which has been proffered to us. So we have no idea what the defense intends to elicit. And I think the court is entitled to an offer of proof to make sure that improper questions are not asked, to make sure that areas are not gone into which are impermissible or improper. And perhaps the defense needs to know what areas the court thinks are proper and improper, or which areas might open doors the defense does not want to open. And a good example of that would be the letter that's been offered so far. But I think that it is clear that in the absence of a statement having been given to the people that will indicate what the boundaries of the testimony are, that the court is entitled to an offer of proof before that witness testifies, and people are making that request.
Mr. Cochran.
I find it particularly ironic, Your Honor, that the prosecution has called some 58 witnesses and took almost 6 months. We didn't try to stop them. This so-called search for truth certainly takes a different turn when the defense gets its chance. Certainly this court, and we talked about this last week, Your Honor, you and I, has an absolute right to ask for an offer of proof, and you did. And I told you, and you were in chambers that indicated, in the areas that I went into, you said it's absolutely irrelevant and totally permissible. Your Honor, these people, the prosecution does not have a right to take each one of our witnesses and ask what we're going to testify. I mean, they're so insecure about their evidence. Listen, if this is a search for truth, you are going to do the right thing with regard to the evidence. We are experienced lawyers. We're not going to go far afield with this jury. We're going to bring on the areas we know about opening doors. And quite frankly, if there is a question about opening a door, we want a ruling. We want a ruling before we ask the questions. And I've indicated to you we will be doing that. And I've indicated the general areas we'll talk about. I mean, it's preposterous for experienced lawyers to stand here and say, Arnell Simpson was the person awakened by the police officers, Your Honor, shortly after 5 o'clock on the 13th. I mean, it's preposterous. She was home that evening. I mean, for them to say this is just preposterous because they don't have a report. There is no report. And as I indicated on Friday, when they're at some point later in their careers, when they practice on both sides, they'll understand how things perhaps work better. Now, I've heard Ms. Lewis, of course, indicated to me she'd never be on this side, but you have to have a client to be on this side. And, you know, and I just
Well,
want to...
counsel, we don't need to go into
Right.
that.
But the point is, Your Honor, I think that we've done this already. I tried to indicate that to the court, and we were very aware of that. And I told you further that both Mr. Shapiro and I and each lawyer will be taking witnesses in these first witnesses. If there's a question mark in our mind, unlike what happened in the People's case, we will ask to approach the bench and ask some advice on those questions, Your Honor.
All right. Thank you, counsel.
Thank you, Your Honor.
All right, counsel, the way we will proceed is accordingly. Where there is a witness, where there is no statement available, I will ask and expect an offer of proof. As to the first witness, Arnell Simpson, this person is well known to counsel on both sides. Her ability to testify to what was going on at the Simpson residence the night of the crime, what occurred that morning, what occurred in the few days afterwards, the demeanor of the defendant, any statements that may have been made by Mr. Shipp. I mean, she is potentially competent to testify to a number of issues that are obvious to me. So I don't think I'm not going to expect an additional offer of proof beyond what we discussed in chambers last week as to Ms. Arnell Simpson. All right, anything else? All right, let's have the jurors, please.
One question on the issue of the letter that they will attempt to introduce through Arnell Simpson. Can we have a list of the P's and A's they intend to argue and provide the court? Can-
Mr. Ullman is here. Mr. Gordon, you want to chat with Mr. Ullman? Sure. And Mr. Cochran, who is going to do the direct examination of Ms. Simpson? All right. And Mr. Cochran, who comes after Ms. Simpson?
I would suspect that Ms. Carmelita Durio will be talking.
All right. Carmelita Durio.
There's the issue of the exclusion order, the court issue. The Brown family is victims as far as being excluded from the proceedings when there was testimony being provided by other witnesses that might relate to
Excuse me, Ms. Simpson, hold on.
their testimony.
We need the jury first.
Okay. So you interested at all?
Yes. Mr. Cochran? Exclusion of other family members when they're going to be testifying as to the same issues.
Okay, I expect that Ms. Simpson will also be testifying sometime this morning. Being she's in a wheelchair, are you asking Ms. Simpson to be mother be moved also?
Anybody who's going to be testifying to the same issues, yes. They should not hear each other's testimony. All right, so they'll be excluded.
Case that there's no law or authority.
And counsel, our lunch recess today will be until 1:30. And let the record reflect that we've now been rejoined by all the members of our jury panel. Morning, ladies and gentlemen. See everybody's well. Great. All right, at this point, Mr. Cochran, you may call the defense's first witness.
Thank you very kindly, Your Honor. Good morning, Your Honor. Good morning, ladies and gentlemen. Good morning. Your Honor, the first witness that the defense will call is Ms. Arnell Simpson.
All right, Ms. Simpson, would you come forward, please?
Yes, I do.
Please have a seat on the witness stand and state your first and last name for the record. Arnell Simpson, ARNELLESIMPSON.
Good morning, Ms. Simpson.
Good morning.
Ms. Simpson, are you acquainted with the gentleman at the end of counsel table there, Mr. O.J. Simpson?
Yes, I am.
And how are you acquainted with him?
I'm his daughter.
And do you have other brothers and sisters?
Yes, I do.
And tell us about your brothers and sisters, their names and approximate ages.
Jason, Sydney, and Justin.
And can you tell us approximately their ages?
Jason is 25, Sydney is 10, and Justin is 6.
And you're still young enough that I can ask this. How old are you?
26.
And then you're the oldest of the Simpson siblings?
Yes, I am.
What was your date of birth?
12/4/68.
Something unusual about that particular date?
I was born the same day my dad won the Heisman Trophy.
And now, with regard to Your background. Have you attended college?
Yes, I have.
Where'd you attend college?
I went to the University of Colorado and then transferred to Howard University in Washington, D.C.
And at some point, did you finish Howard University?
Yes, I did,
When was that approximately?
in 92.
All right, now after you finished college, and Howard University is in Washington, D.C.?
Yes, it is.
Did you then have occasion to return back to Southern California?
Yeah, periodically through the holidays.
All right. And prior to that and after that, did you have occasion to relocate here to Southern California, move back here and live here?
Yes, I did.
When was that approximately?
In 92, September of 92.
And that was after finishing, is that
Yes,
correct?
it was.
Did there come a time thereafter that you had occasion to move back to the Rockingham residence that we've heard about in Brentwood?
Yes, I did.
Now, had you lived in Rockingham at some time earlier in your life?
Yes, I have.
Do you recall when that was approximately?
Off and on my whole life.
All right,
basically.
well, when you were a young lady, was your father married to your mother?
Yes,
And what's your mother's name?
Marguerite Thomas.
And is she present in court here today?
Yes, she is.
And she's the lady there with the pretty flower on her, the yellow?
Yes, she is.
All right. And when did you first move into Rockingham, if you recall, as a youngster?
I was, I believe, 7 when I first moved in with my mother and father.
And can you move a little closer to the microphone?
Oh,
Councilman?
sorry.
No, I just want you to pull it closer.
Pull it.
There you go, thank you.
Thank you. I'm sorry, I missed that last answer. You were approximately 7 years of age?
Yeah, I believe so.
And at that time, was that a home? Was that the family home?
Yes, it was.
And who lived at that house at that time?
My mother, my father, myself, and my brother, and my sister Erin, and then she passed.
You had a sister, Erin, who
Yes.
ultimately passed? All right. But so this was a family home purchased at that time, is that correct?
Yes, it was.
Okay. And how long did you live at Rockingham after you moved in at about 7 years of age?
I lived there until 87 when I graduated from high school.
All right. From high school?
Mm-hmm.
All right. Got to say yes?
Yes.
All right. Now, then from 87, after 87, you lived other places, is that correct?
Pardon me?
You didn't live at Rockingham after 87
No.
for a while?
I went off to college.
Okay. Then after now you had finished college, did there come a time in 1993 that you moved back into Rockingham?
Yes, I did.
All right, we tell the ladies and gentlemen of the jury when that was that you moved back into Rockingham.
It was approximately, probably early March of 93.
All right, and what were the circumstances surrounding your moving back? Did you have a conversation with your dad?
Yes, I'd asked him if I could move in.
So-
Sustain.
The yes would be appropriate, that seems to me.
Yes.
Okay, you had a conversation with your dad, is that
Yes.
correct? And in that conversation, did the two of you discuss your moving back into Rockingham?
Yes, we did.
Yes or no? All right. And was anyone else present during that conversation that you had with him?
Yes,
Who was that?
Paula Barbieri,
And who is Paula Barbieri?
my father's girlfriend,
All right, and where did this conversation take place?
in our TV room at the house.
All right, in which house? You're talking about Rockingham?
360, yeah.
All right. You can tell us, why was it that you decided you'd want to move back at home at that point, just generally?
At the time, I was living with my mother, and she had a duplex and wanted to rent out the place I was staying in. And I'd asked my dad if I could move in, and he said yes.
Okay, he said, okay, he indicated yes.
Yes.
Okay, we won't go into the conversation. But, so, the reason was you wanted to move from your mother's residence and you wanted to move back home, is that right?
Yes.
Okay. Now, when you lived at Rockingham when you were a youngster, did you have your own room?
Yes, I did.
And did your brother Jason have your own room?
Yes, he did.
All right. At some point after you moved out, did your father remarry?
Yes, he did.
All right. And the rooms that you'd had, who occupied the rooms that you originally had when you were a young person? Did your younger brothers and sisters
Yes.
take over those rooms?
Yes, they did.
And that's Sydney and Justin?
Yes.
All right. So when you moved back, or when you wanted to move back, where were you going to move at that point? Which room were you going to move in, if you know?
Because Justin and Sydney were occupying our rooms, Dad built 2 additional rooms in the back for us so that we would have a place to stay.
All right. So he built 2 additional rooms. If I were, may I put you on? There's a diagram that's been previously marked, and I'd like to, people's.
People 66 room.
All right, people 66, which is the diagram of the Rockingham residence.
Thank you. As I understand it, this particular exhibit is now in evidence, as I understand.
It is.
Is that correct? Ms. Simpson, with regard to People 66, which purports to be a diagram of the grounds at 360 North Rockingham Avenue, you've seen this diagram before, have you?
Yes, I have.
All right. And you were just describing for the ladies and gentlemen of the jury in the court that your dad had built some additional rooms after his new family had moved into Rockingham. Is that correct?
Yes.
And can you show us, if the court will allow you to step down briefly, and show us where the rooms were that your dad had built for you and your brother, Jason? All right, for the record, Your Honor, Ms. Simpson has indicated 2 areas on People 66 marked Arnell's room, and she indicates both of those rooms, of course, business.
Yes.
And those are the two rooms that you and your brother Jason could occupy, is that correct?
Yes.
So after this conversation with your dad and Paula Barberi, did you have occasion to move back into Rockingham?
Yes, I did.
And in the course of the conversation that you had with your dad, did Paula Barberi also participate in that conversation?
Yes, she did.
All right. Now, when you moved back into Rockingham, I think you told us that was perhaps around March or so of 1993.
Yes.
Did you have any special arrangements whereby you were going to pay rent or whatever?
Yes, I did.
And what was that?
That I would move in and give my father $50 or $100 a month so that when it was time for me to get ready to leave, I would have money for a down payment for a first and last rent.
Would you get the money back?
No.
You would get the money back from your dad? if
Oh,
you
yes,
moved?
if I were to move, yes.
All right. But did you always pay the $50 or $100?
In the beginning, I did, then it kind of slacked off.
All right. But you didn't. You weren't put out at any rate, were you?
No.
All right. Now, so starting then in March of 1993, you moved back into the residence. Is that
Yes.
correct?
Yes, I did.
Now, I want to ask you a question about the family dogs. Did you have a dog back in the early part of 1993, or dogs at the Rockingham residence?
Yes.
Okay, tell us the names of those dogs.
Chachi and Chubbs.
Okay, now Chachi we've heard about, and is that the black chow that we've heard about?
Yes.
And do you know how long you'd had Chachi approximately?
Oh, goodness. It's been about 9 years.
All right, so he's a 9-year-old dog or
Yes.
something like that?
Uh-huh.
All right. And he's the black dog we've heard about, is that
Yes.
right? Okay. And you mentioned a new name, Chubbs. Who is Chubbs?
Our other dog that we had.
All right, and what kind of dog was Chubbs?
A chow, a brown chow.
All right, and you know how long you'd had Chubbs prior to 1993?
About 11, 12 years.
Was Chubbs older than Chachi?
Yes.
All right. Did something unusual happen to Chubbs?
Yes, he died.
And were you in and around the Rockingham residence when that happened?
Yes, I was.
And after that, did something unusual happen after Chubbs had died?
Yes.
What was that?
We buried him.
All right, now, with regard to this, and this dog, you were attached to this dog?
Yes.
And what about the younger children?
Yes.
And at that time, and when did he die exactly?
He died either end of February, maybe beginning of March of 93.
All right, at that time, was Miss Nicole Brown Simpson, do you know where she was living at that point?
Yes.
Where was she living?
Gretna Green.
And were you acquainted with that residence?
Yes.
And would you occasionally go over to that residence?
Yes.
How often would you go over to the residence when she lived at Gretna Green?
It was very close, so I would stop by periodically to say hello and see the kids, sometimes do errands with her.
All right. And did you make Miss Nicole Brown Simpson aware of the fact that this dog Chubbs had died?
Yes.
All right. Did something happen thereafter?
Yes, she came over.
All right, look at it. Thank you. You may answer.
Yes.
And what happened?
At that point, my father, Nicole, and I proceeded to figure out what we were going to do with Chubbs, and we decided to bury him in the front yard
He's buried in the front yard of Rockingham?
of the Rockingham house.
All right. And was this a procedure that took place on the day you found him?
Yes.
Where'd you find this dog?
He was in the pool.
All right. Now, with regard to this procedure that you had where the dog was buried, was he buried in the front yard of Rockingham?
Yes.
All right. How'd that take place?
We didn't want to give him to anybody because we had the dog for so long, so Nicole had actually made the decision to bury the dog in the front yard, and she dug a hole in the front yard.
And he's buried in the front yard?
Yes.
Did your father try to dig that hole?
He attempted to.
And what'd you see him do, if anything?
He couldn't do it.
Relevant.
Sustained.
I'd like to make an offer with regard to that.
Sustained. 93.
There we go. So Mr. Cole Brown Simpson dug this hole, is that correct?
Yes.
All right. And were the younger children also present at the time?
No, they were not.
Okay, just who was present at the time the dog was buried?
My father, Nicole, and myself.
All right. Now, after Chubbs had passed on, did your father have occasion to buy another dog?
Yes, he did.
And what was that dog's name?
Cato.
And so when was Cato bought in relationship to the time that Chubbs died?
Maybe 2 to 3 weeks later.
All right. And your dad bought that dog?
Yes.
All right. And where, at that point and thereafter, where would Cato live?
At my dad's house.
Okay, at Rockingham?
Yes.
So how many dogs did you have again at this point?
2.
So that you had both Cato and Chachi living at Rockingham, is that correct?
Yes.
All right. Would there ever be occasions when Cato would be over or taken over to Mr. Cole Brown Simpson's residence?
Yes.
All right. And at some point, did she move from the location at Gretna Green to some other location?
Yes.
Do you know when that was approximately?
I believe it was the end of 93.
All right. And did you Did you in any way, were you aware about the time that she moved? Did you participate in that move at all?
No, I did not.
All right, you knew when she moved, is that right?
Yeah.
All right, and that's when she moved to Bundy, is it?
Yes.
Okay. Now, then Cato, you've described for us, was living at the Rockingham residence primarily, is that right?
Yes.
Along with Chachi, is that right?
Yes.
Okay. Would there ever be times when Miss Nicole Brown Simpson would come by and get either one of the dogs, Cato or Chachi?
Yes.
Describe that for us.
She would come by in the mornings and either take the dog over to see the kids, or she would run with the dog.
Okay, and which dog would she run with primarily, if you recall?
Cato.
All right. And would you ever run with Chachi?
No.
And why was that, if you know?
Chachi has really bad arthritis.
His arthritis?
Yes.
All right. But Cato, was Cato a younger dog?
Yes.
All right. So she would run with Cato?
Yes.
Would she take Cato with her?
Yes.
All right. And would there be times when Cato would stay overnight over at the Bundy residence?
Yes.
Now, your dad has several cars, is that correct?
Yes.
And when you moved back in 1993, how many cars did he have at that point in and around the Rockingham residence?
3.
And we've heard about a black Bentley.
Yes.
Is that one of the cars?
Mm-hmm.
And do you have a white Bronco?
Yes.
And you have another car?
Yes.
And where's that car?
In the garage.
All right. That's a third car, is that correct?
Yes.
All right. Now, with regard to the Bronco, what family members, if any, would drive this Bronco vehicle that your dad had?
Everybody.
And by everybody, who do you mean?
Myself, my brother, AC, Nicole, my father.
All right, and so we get some names, some new names here. When you say AC, who do you have reference to?
Alan Collins.
Collins, is that Cowlings?
Yes.
Alan Collins. And is that a friend of your dad's in the family?
Yes.
Okay. And you told us that Nicole would drive the Bronco?
Yes.
And you would drive the Bronco?
Yes.
And when you say your brother, I presume you mean your older brother, Jason?
Yes.
By the way, I may have neglected, is this your older brother, Jason, in the courtroom sitting next to your mother?
Yes.
To the right of your mouth? Now, do you have a recollection of seeing Miss Nicole Brown Simpson drive that Bronco from the time that you moved back in over the course of the last couple of years?
Yes.
Do you recall under what circumstances she would tend to drive the Bronco?
Either to take the dogs. At one point, her car was in the shop, or to use the car with Justin and Sydney if they had other kids with them, friends of Justin and Sydney's.
To go out like on outings or whatever?
Yes.
Have you ever seen times when she had one or both of the dogs inside the Bronco when she took it?
Yes.
Try to limit. Have you seen times when she's had one or both of the dogs in the car?
Yes.
Will there be one dog taken in the car more often than another?
Yes.
And which dog would she take most often?
Cato.
And the children would also be in the car on occasion?
Yes.
Now, after you moved in March of thereabouts of 1993, would you have occasion to see Mr. Nicole Brown Simpson or the children over at Rockingham on times after you moved in March of 1993?
Yes.
Would you describe for the ladies and gentlemen of the jury the circumstances by which you would see her over at the Rockingham residence?
She would come over in the mornings, sometimes to let the kids swim, or she would drop them off while she went running, and I'd watch Justin and Sydney. And she would come over sometimes to pick up her mail.
All right, she had mail that would still come to that residence?
Yes.
All right. If you are aware, you'd been over to the Bundy residence, had you not?
Yes.
Did she have a pool at Bundy?
No.
So the kids like to swim?
Yes.
And there is, in fact, is looking at People 66, a pool area that we've all seen on our jury view at Rockingham. Is that correct?
Yes.
Now, would you know the time she was coming over there to bring
No.
the kids? All right. And so how would you determine she was there or find out she was there?
I'd wake up in the morning, and sometimes I'd walk outside. She'd be out laying out, and the kids would be in the pool, or I'd come inside the house, and she'd be in the kitchen, or we'd be going and passing.
All right. And during this time frame, she and your father were somewhat separated. Is that correct?
Yes.
All right. And would I be correct in assuming that when you first moved back in, his girlfriend at that time was Paula Barbieri?
Yes.
All right. Now, the times that you would see Miss Nicole Brown Simpson over at the Rockingham residence, did that continue on for a period of time after you got back in March of 1993?
Yes.
Now, with regard to your relationship with Miss Nicole Brown Simpson, would you have occasion to ever go over to the Bundy residence?
Yes.
And under what circumstances would you go over to Bundy, ma'am?
To stop by, to say hello, to talk to the kids. On occasion, she would call me to babysit the kids in the morning so she could jog or to take them to school.
And were there occasions that after you moved back into Rockingham that you would babysit the children at Bundy?
Yes.
Now, with regard to your dad, Mr. O.J. Simpson, if you know, were there times when he would spend the nights, this is after you came back in March of 1993, over at the Bundy location?
Yes.
See if she knows. And how do you know that he would spend the night over there? Have you explained that for the court jury?
He would call me to see if anybody was at the house. Sometimes call me if they wanted something from the Rockingham house for me to bring over to Nicole's house.
And would there be occasions where you would bring things from the Rockingham house over to Bundy and he would be there?
Yes.
And what kind of things would you bring over there?
Like Justin's Nintendo game or a video.
All right. Did the children have games like Nintendo and other kind of videos at Rockingham?
Yes.
They also have some Nintendos and games also at Bundy?
Yes.
Did you ever have occasion to bring any clothes over for your dad from the Rockingham residence over to Bundy?
Yes.
And we're talking, so that we're clear for the time, we're talking about primarily after you'd moved back in, is that correct?
Yes.
And do you recall specifically when the times were that you have had occasion to bring clothes over to your dad, the times he was over at Bundy, if you recall?
Yes.
Tell us about that, please, now.
It was between 93 and 94, during the summertime.
The summer of 93?
Yes.
Thereabouts? Did there come a time when you started to see Nicole Brown Simpson and your dad, Mr. O.J. Simpson, start to go out together again?
Yes.
And when was that approximately?
It was probably around the month of March or April of 93.
All right. Was this about the time when you would see her out by the swimming pool and things like that?
Yes.
Okay. And then after he started to see Miss Nicole Brown Simpson again, if you know, did you stop seeing Paula Barbieri?
Yes.
All right. So. And so then, once he started seeing Nicole Brown Simpson again, he wasn't then seeing Paula Barbieri. Is that correct?
Yes.
All right. And with regard to the time that Mr. Nicole Brown Simpson moved to the Bundy location, did you think that was near the end of 93 or the first of 94? Do you know when that was?
I believe it was the end of 93.
All right, so somewhere around that range, is that
Yes.
right? Okay. So this time frame then that you've described where you would take clothes over to the Bundy location would have been in the summer of 93, and that was a time when your dad was again going out with or dating Miss Nicole Brown Simpson. Is that right?
Yes.
Now, during this time that they were seeing each other, she never moved back permanently to Rockingham, did she?
No.
She moved in the house, did she?
No.
All right. Would there be times when she'd come over though and spend some time at the house?
Yes.
And would describe that. Did that continue to happen over a period of time?
Yes.
And did they continue to date, if you will, from the time you talked about in April or May throughout 93 into 94?
Yes.
And would you see her fairly frequently during that time frame?
Yes.
Sustain.
All right. Well, will you describe for us how often you would see her during this time frame after they started dating?
Almost every day.
And just describe for us a general day, if you can picture for us. We're now talking about after the time that they got back together.
Can you rephrase that?
Okay, certainly I will. The question I was asking was whether or not they tended to see each other at both locations, both Rockingham and Bundy. And I was going to ask you to describe a day when you might see Miss Nicole Brown Simpson at Rockingham, first of all.
She would come over during the summer. At one point, we had all gone to a movie, the whole family. They had thrown a couples party, and she would be over at the house. Or he would be over at Nicole's house, and I would go over there, like I said before, and drop off clothes.
All right. Okay, and so with regard to this time frame, are you sure of the exact dates of the time that Miss Nicole Brown Simpson moved from Gretna Green to Bundy?
I'm assuming end of 93, but no, I'm not correct. I don't know the exact date.
All right.
No.
You know that at some point she lived at Gretna Green. You
And
know
then
at some
moved-
other point she moved to Bundy?
Yes.
All right. Now, with regard to the late summer, in the month of August or thereabouts of each year, were you aware of how your dad was employed at that time?
He would start his football season.
All right. Was he a sportscaster of some kind?
Yes.
All right. And when he started his sportscasting, did something unusual happen, or did he have to move locations?
OJ did
August of
football?
19,
When?
like that? Would he have occasion to move his residence in the month of August or in the late summer?
Yes, he would.
All right. And where would he go during this time frame, if you know, ma'am?
He would move to New York and then travel out of New York.
All right. And to the best of your recollection, again, what month would that normally be he'd move to New York?
It would usually be between the months of August until January.
All right. And you said he would move to New York. Did he have a residence in New York?
Yes, he did.
And what kind of place did he have in New York?
He had an apartment.
And you've been to that apartment, of course?
Yes.
Now, you described for us that you were attending Howard University in Washington, D.C., is that correct?
Yes.
And so would you have occasion to see your dad or visit your dad when you were in D.C. and when he's up in New York,
Yes.
when you were back there? Would you ever go to the New York apartment?
Yes. Often.
Now, during that time frame, after Miss Nicole Brown Simpson and your dad started dating again, do you recall whether or not you ever had occasion to see them together in New York at any time?
Yes.
Can you describe that for us?
It was no different than the normal. It would usually be on some of the holidays, sometimes the weekends. It would be easier for me to go to New York as opposed to flying all the way to LA from Washington, D.C. So,
All right. So there would be times you would see the family there?
yes.
And would that include the two minor children also?
Justin, Sydney, yes.
And yourself?
Yes.
Now, when you moved back into the house that you described for us in March of 1993, were you given any particular instructions about your role around the house there?
Yes.
And what was that?
That basically I had become the woman of the house, and while he was gone, for me just to make sure that everything was running in the household and to just watch it.
All right, so now, as you became the woman of the house, do you recall whether or not in the month of August of 1993, did your dad go into sportscasting or broadcasting and have occasion to go to New York during this time frame?
Yes.
So there'd be periods of time when he wasn't even here in California?
Yes.
And were you the woman of the house?
Yes, that's the reason why he made me the woman of the house.
All right, and as the woman of the house, what kind of things would you do?
Just make sure everything was running, as far as the gardener and people coming into the house, regulating it, watching, the cars, just household things.
All right, well, there was a housekeeper?
Yes, there was.
All right, and would the housekeeper be there on weekends?
No.
And so on weekends, you really have to be the woman of the house then, is that right?
Yes.
All right. So you did this in 93 after you moved in, is that correct?
Yes.
And primarily he was traveling and doing his sportscasting work
Yes.
from August on? And that would last how long? Say till January?
Yes.
All right, and that's,
Oh, yeah, August to January.
all right, and there's some big football game that occurs toward the end of January called the Super Bowl?
Yes.
All right, is that,
So if you have a gardener and a housekeeper, what do you have to do? Like, what's left for you to do? I wonder what their days are like.
traditionally in the football season?
Yes.
All right. After that, would he stay in New York, or where would he go at that point, if you recall?
He was in LA, but he would travel quite a bit too.
All right, now, he would travel a lot.
Yes.
And you were living, and so I'm not sure we made it clear for the jury, but after you moved back in, you described for us that Mr. Simpson had built rooms for you and Jason, and you described them as Arnell's room back here.
Mm-hmm.
And I don't think I asked which room you moved into. When you moved back in, where did you move, do you recall? Let me step down here.
Yes.
Thank you.
I was living here.
All right. The room marked Arnell's room, Your Honor, that's next to Cato, correct, that's next to the room marked Caton's room.
Yes, to the right of that.
To the right of that, thank you. All right, so that's the room you moved into. So this is the room from which you were the woman of the house, right?
Yes.
Okay. Now, you were describing for us that your dad would travel a lot, even when there was no football season, is that correct?
Yes.
And would you talk to him about his travel? Would he tell you when he was leaving?
Sometimes.
And do you know why he was traveling, what he was doing during this period of time?
That's vague, Counsel.
Yes, Counsel's correct. You're correct. Let me rephrase that. Do you know what kind of trips he was taking during this period of time after, say, January of 1994?
Yes.
And what kind of trips were they? Business trips?
Some were business, some were pleasure.
All right. He'd go various places?
Yes.
All right. And he do this on a regular basis?
Yes.
All right, let's talk a little bit about your dad's traveling habits as you knew them. And we're talking now for the period after January of 1994. Let's say between the period of January and, say, June of 1994. Have you ever been around when your dad was getting ready to leave for a trip?
Yes.
Can you describe for us any particular things about his getting ready, his packing habits, and those sort of things?
Overruled.
He would usually do everything last minute.
And you've seen this yourself?
Yes.
And describe that, doing things last minute.
Well, there's always been an ongoing joke within the family that we'd always say, Dad, you have to get ready. And he'd always say, I'll get ready before you will be. And I would always prepare an hour before, and he'll get dressed in the last 15 minutes before we would have to leave.
This is
He's done this for years.
That's something that you've seen. As you
Cameraman, we do
Yes.
not need
And
to
so
see
it must
this.
be a race. He was going to
This is
first. He would start
disgusting.
much behind you.
Yeah.
All right. And you've seen that happen over a long period of time, have you?
Hey,
Yes.
girl.
Now, I'd like to shift our attention now. You described for us that when you first came back or talked to your dad about coming back, you'd met a lady by the name of Paula Barberi, and she was present during this conversation. Is that correct?
Yes.
Had you known her before the time you came over and talked to your dad, before you moved back in?
Yes.
And do you recall approximately when it was that you first met Miss Paula Barberi?
It was in 92.
And under what circumstances, if you recall, did you have occasion to meet her?
When we'd have phone conversations when I was at school, and he told me he had met somebody.
All right, and then so you had a conversation, you came west. Did you have occasion to attend any particular event where you had occasion to formally meet Ms. Barbieri?
Yes.
And what was that occasion?
Paula had thrown my father a birthday party on July 9th, which was yesterday, but in 94.
That's his birthday, July 9th?
Yes.
And this party was in 1992?
Yes.
All right. And was that when you,
Yeah.
did you meet her at that time?
Yes.
All right. And where did this birthday party take place?
At our house.
And the house, you mean, again, the Rockingham residence?
Yes.
That's always the house, right?
Yes.
All right.
Sorry.
Okay, so there was a birthday party on July 9th, 1992, his birthday, when you first met her?
Yes.
All right. Now, did you have occasion to discuss with your dad his relationship with Paula Barbieri? Can you answer that yes or no?
Yes.
And you talked about those kind of things?
Yes.
And during the time, and since you were an adult during this time, and after the time you moved back into the house, would you have occasion to discuss with your dad various subjects, serious subjects such as relationships?
Yes.
Did you have occasion to discuss with him his relationship with Paula Barbieri?
Yes.
At any time, did you have occasion to discuss with him his relationship with Nicole Brown Simpson?
Yes.
Now, I want to direct your attention now to the week of June 6th, 1994. In that particular week, do you recall whether or not your father was home the entire week, or was he away during part of the time, or what was the circumstances?
What year was this?
The week of June 6th, 1994. Do you recall whether your father went out of town at all that week?
He had been coming and going, yes.
All right. And again, was that like a regular week for him?
Yes.
All right. So you became aware that sometime during that week he left and went out of town. Is that correct?
Yes.
Okay. Now, prior to that time, the time we're now talking about, June 6th or thereabouts, there come a time when your dad and Nicole Brown Simpson stopped seeing each other again, if you recall.
Yes.
Was that sometime after Mother's Day of 1994?
Yes.
Around that time?
It's around, Mother's Day.
All right. Now, during the time, you've told us that during the time that Mr. Simpson was seeing Nicole Brown Simpson, he was not seeing Paula Barbieri. Is that correct?
Yes.
And after this time when Mr. Simpson, your father, was no longer seeing Miss Nicole Brown Simpson, did you have occasion to again see Paula Barbieri?
Yes.
Was that after he'd broken up with Nicole Brown Simpson?
Yes.
And again, would that be after Mother's Day or so in May of 1994 that you saw Paula again?
Yes.
Did you have occasion to discuss the various things that were taking place in your father's life at that time with him at all?
Yes.
You're somebody he would come and talk with?
Yes.
Prior to, strike that. Back to this particular week that we were talking about, the week of June 6, 1994, you described for us that you became aware that your dad went out of town that particular week. Recall that?
Pardon me?
You described for us that your dad went out of town during the week of June 6,
Yes.
1994. Prior to that, before that June 6th week, do you recall a time that after your dad and Miss Nicole Brown Simpson were no longer dating, that she became sick with pneumonia?
Yes.
You recall that?
Yes.
Was that in the month of May after they had broken up as well? I'm asking.
Sustained. Rephrase the question.
Certainly. When was that? When was that when she came down with pneumonia, if you recall, your best recollection?
Sometime in the month of May.
All right. And tell us what you observed with regard to that. Did you ever see her at the house, the Rockingham residence in that time frame?
No.
All right. Were you aware of her being at the Bundy location?
Yes.
And were you aware of whether or not your father did anything in taking care of her during this time frame? I'm asking.
Full rules. Foundation sustained.
With regard to whether or not your father cared for Mr. Nicole Brown Simpson when she had pneumonia, how do you know that? What are the circumstances?
Sustained. Rephrase the question.
Certainly. Did you have occasion to see Nicole Brown Simpson during this period of time when she was supposedly sick?
Yes.
Have you described that for us and tell us where you saw her?
I saw her once at Justin's graduation, and then I went over to her house one day.
All right. And when you say went over to her house, you went to the Bundy location?
Yes.
And you became aware that she was sick?
Yes.
And what was her ailment at this time?
She had pneumonia.
And with regard to that, were you aware of whether or not your father did anything or visited her during this particular period of time?
Yes.
Tell us what you observed in that regard.
He went over to her house one day to help.
Full rules.
He went over to the house to help her one day with the kids and to bring her some soup and medicine, see if she was okay.
All right. And this was during the period of time after they had broken up and while she was sick. Is that correct?
Yes.
All right. Now, back again to this week of June 6th, on this particular week. Did you become aware toward the end of the week, specifically, I guess, around Friday, June 10th, did you become aware of your father coming back to California?
Yes.
Do you recall when you saw him in and around that period of time, June 10th, June 11th, if at all?
I don't believe that I saw him on that day.
All right.
Not in person.
All right. Were you aware he was back in town, however?
Yes.
All right. Do you recall whether or not you saw him at all on the Saturday, which would be, I think, the 11th of June?
No.
All right. And on Sunday, June 12th, 1994, did you spend the previous night, the Saturday night, in your residence, in your room there on People 66 as indicated?
Yes.
All right. And did you have occasion on that morning to get up and go someplace?
Yes.
And where'd you go at that time?
I went to church.
What church did you go to?
St. Martin's.
All right, that's a church out near in Brentwood there?
Yes.
All right. And after you went to church, what time did you go to church?
I went to church at 10.
And did you have occasion to return home after that?
Yes.
And did you see your father at all that morning?
No.
Were you able to ascertain, do you know where he was at that point?
No.
Do you know he's back in town?
Yes.
All right. How'd you know that?
Because Gigi had told me, the housekeeper, that Dad was coming in town on Friday and that he would be leaving at the end of the week.
All right, so you had a conversation with the housekeeper?
Yes.
And her name is Gigi?
Yes.
All right. Her last name is Guerin?
Yes.
Is that Guarin?
I believe so.
All right. So you went to church and you came back home, and after you went to church, did you have occasion to go out?
Yes.
And were you out pretty much the whole day?
Yes.
And now did you have a car?
Yes.
Vehicle? And what kind of vehicle did you have?
A Saab.
And what color is it?
Black.
And what year is it?
94.
And when did you get that car?
And 93.
Did you have that car when you came back to the Rockingham residence, or did you get it after you got there, or when did you get it, if you recall?
Can you repeat that?
Certainly. Did you have that car when you moved back in with your dad?
Yes.
In March of 1983?
Yes.
All right. Had that car been a graduation present for you?
Yes.
All right. And so where was that car, where did you traditionally park that car when you were home at the residence? Can you show us that?
Yes.
Again, first edition?
Yes.
She's looking again at People 66, Your Honor.
Where this red dot is.
All right, she's pointing toward a red dot on People 66, and it's above the words driveway.
Yes.
On the diagram. And you parked your car traditionally there, is that correct?
Yes.
And if you can show us, was there a place on that diagram where the Bentley was normally parked? And that's the black Bentley you talked about earlier?
Right here.
All right, and that would be right in front of your car, and she's pointing to an area, Your Honor, above drive and the words driveway on People 66.
Yes, to the left of the red dot.
Left of that. And left of the red dot. Is that where you parked your car normally, where the Bentley was parked?
Yes, usually we both park our cars in this right here.
All right, oh, in that
In
little
this,
kind of inset area?
Yeah.
All right.
Yes.
There's both of you try to park your cars in that location?
Yes.
And the Bentley, as I understand your testimony, would be in front, is that correct?
Yes.
All right. So, when you left the house on Sunday, June 12th, after you'd come back from church, how'd you leave? You leave in your car, or how'd you leave?
I left in my car.
All right. And you did not return until what time?
Approximately around between 12:30 and 1.
And is that a.m.?
Yes.
All right. Had you been to a movie or something like that?
Yes.
All right. And you returned home about 12:30 or 1, is that
Yes.
correct? When you returned home, you didn't see your dad, did you?
No.
All right.
He'll
Did you
stand.
see your dad?
No.
And were you aware of whether or not he was going to go out of town again?
Yes.
And if you can just tell us, how did you know that?
Prior to Gigi telling me.
Sustain. Yeah,
You're not allowed to say what someone else said, woman. You're not allowed to. You just did. Sanctions. Can the judge give sanctions to her other than contempt? All right. So mad I missed everything today. So excited. And it's OJ's daughter. I hope you guys had a great day watching this. Yes, sir. Yes, sir. We made it. Oh, man. It's going to be great from here on out. Don't you worry. You guys have a great day. And I shall see you all again very, very, very soon. Thank you so much for watching this with me. I really appreciate it. Bye, guys.